Dear sirs and madams, good morning. We would like to welcome you all to the Nova University of Lisbon and to our conference entitled Innovation of University Teaching in a Digital, Multilingual and Globalized Society, a perspective from the project CALESA. This event has been organized within the scope of the Erasmus Plus project, CALESA, that stands for Capacity Building for Legal and Social Advancement in the Philippines. The project is supported by the European Union and coordinated by our dear partners from the University of Malaga. We are happy and honored to be the host of this event, and we warmly welcome you on behalf of our colleagues and staff members of the Nova University and of our Nova School of Law. Before starting with our conference program, we take a moment to pay homage to our countries in dialogue. Please, we kindly invite everyone to stand up for the national anthems of Portugal and the Philippines. Please welcome to the stage please take your seats, and please welcome to the stage Professor Margarida Lima Rego, Vice Dean of Nova School of Law, who will deliver the opening greetings.
Honorable Alexander Gesmundo, Chief Justice of the Supreme Court of the Philippines. Honorable Mario Lopez, Associate Justice of the Supreme Court of the Philippines. Honorable Rosemary Carandang, Chancellor of Philippine Judicial Academy. Honorable Mariano del Castillo, Vice Chancellor of the Philippine Judicial Academy, Her Excellency Celia Ana Feria, Ambassador to the Philippines to Portugal, Mr. Reginald Barnaby, Consul General of the Philippines, Honorable José João Abrantes, Counselor Justice of the Portuguese Constitutional Court, Professor Edgardo Carlo Vistan, Dean of the University of the Philippines College of Law, Professor José Mari Tirol, Dean of the School of Law of the University of San Agustin, Professor José Maria Ofilenia, Dean of Ateneo de Manila University School of Law, Professor Maita Chan Gonzaga, Vice Dean of Ateneo de Manila University School of Law, Professor José Manuel de Torres Perea, Coordinator of CALESA project, representing all colleagues from the University of Malaga, dear colleagues from Ateneo de Zamboanga University, Professor Claribel Concepcion and Miss Marianne Alba, from the University College of Dublin, Professor Marie-Luz Paris and Professor Richard Collins, from the University of Deusto, Prof. Marianne Alaez and Professor Felipe Gomez Isa. Ladies and gentlemen, good morning. It is my pleasure to welcome you here at Nova School of Law and at Nova University. I have to begin by thanking Professor José Manuel de Torres Perea for inviting Nova to join this very ambitious and innovative project. Just by listening to this very long list of honorable participants, we can tell that this is not just any project. We are very happy to be part of this project where we actually engage in very meaningful and mutually enriching capacity building activities. We were very fortunate to be able to have a team of colleagues from Nova School of Law at the Philippines already working on aspects connected to criminal law and commercial law. And now we are doing our best to meet the very, very high expectations that I was given because, of course, our colleagues were so happy and so extremely well received while at the Philippines. I have to thank you for this, and I hope we are doing our best to receive you in the same manner. We at Nova School of Law are very much focused on internationalization, meaning that we would very much like to have all of us, all of our community, professors and students alike, to be able not only to have international experiences in the sense of being able to go to other places and work with colleagues from other places, but also even those who cannot go and who stay here, we are very much focused on making sure that all of us are fully prepared to face the challenges, the global challenges of the 21st century. Unfortunately, or fortunately, depending on the perspective, whether we talk about the physical element, the physical world, or the digital world, in both contexts, the problems that we are facing are increasingly common. In the physical world, we have to tackle global warming, the energy crisis, the issue of our not having a planet B. So we need to take very good care of the only planet that we have, Earth. All of these concerns, our goals to lead a sustainable life in all aspects and to combat poverty and hunger, these goals unite us. And of course, as citizens of the world, fully engaged citizens of the world, we do want to prepare our students to be able to play their role as agents of change, working for a better world. Also in the digital world, if the physical world is increasingly global, the digital is obviously global from birth. So of course we are technologically faced. We really want to provide all of our community with the tools they need to understand and be active players in the digital world. So having said this, it is a great opportunity for us to be able to be part of this very exciting project where together we try to have meaningful scientific discussions on how to move forward in all of those issues that mutually affect us. So I will not take too much of your time. I'm only here to welcome you, and I hope I have done it. And I'm now looking forward to hear the next speeches, which I'm hoping and I believe, I'm sure, will be much more full of interesting information and research results that will engage us all in going forward to this exciting new project. Thank you very much.
Thank you, Professor Margarida Lima Rego. We now invite on stage Her Excellency Celia Ana M. Furia, Ambassador of the Philippines to Portugal, to make the opening statement for this event.
Our host, Dr. Margarita Lima Rego, Nova School of Law Vice Dean, Honorable José João Abrantes, Counselor Justice of the Portuguese Constitutional Court, of course, the Honorable Alexander Gesmundo, Chief Justice of the Supreme Court of the Philippines, Associate Justice Mario Lopez, Chancellor Rosemary Carandang, and Vice Chancellor Mariano del Castillo of the Philippine Judicial Academy, representatives from the participating European, and I say from Malaga, Deusto, and from Dublin, and Philippine universities such as Manila, Cebu, and Zamboanga. Ladies and gentlemen, bon dia, buenos dias, magandang umaga, good morning. It's my honor to give some brief remarks to open this morning's conference entitled Innovation of University Teaching in a Digital, Multilingual, and Globalized Society under the project Erasmus Plus Capacity Building for Higher Education, CALESA. The presence of a high-level delegation from the Philippine judiciary, as well as representatives from the various Philippine law schools and universities and institutional partners, underscores the importance that the Philippines places on this project and its commitment to the project's mission of enhancing Philippine legal and judicial systems through academic training and exchanges. We are confident that this Lisbon conference will see the fruitful exchange of knowledge in the conduct of legal and judicial education and the sharing of experiences, research, and best practices that will serve to enrich the knowledge and enhance the training of law students and all legal and judicial practitioners in the Philippines. As the world evolves and technology rapidly developing, the conference sessions on modernization of law and legal education in a digital world and on resilience in research and development during the COVID-19 pandemic will afford the opportunity for participants to exchange ideas about developments and advances in technology, as well as challenges of a pandemic crisis. The knowledge gained from this exchange of ideas and best practices in these areas are important inputs to aid our legal and judicial education system. The project Erasmus Plus Capacity Building for Higher Education, CALESA, is indeed an effective way to deal with new ideas and practices as they may be relevant in the Philippine setting. It is in this spirit that I wish to thank the proponents and the consortium of institutions behind the project Erasmus Plus Capacity Building for Higher Education, CALESA, for actively engaging their Philippine partners in their many initiatives. I particularly wish to thank the Universidade Nova de Lisboa, in particular its College of Law, for hosting this conference in beautiful, sunny, and rainy Lisbon. The acronym CALESA, which stands for Capacity Building for Legal and Social Advancement in the Philippines, is rather interesting. It's actually a horse-drawn vehicle, carriage with either 2 or 4 wheels. And as the project website explains, It symbolizes the historic ties between the Philippines and Spain, as well as future partnerships towards building a better tomorrow. But there is another symbol of our history that involves the Philippines, Spain, and Portugal. And this is the 5th centennial of the circumnavigation of the world by the Magellan-Elcano expedition, of which the Philippine narratives within the story of this pioneering circumnavigation expedition plays an integral part. Over the past years, the Philippine Embassy in Lisbon has actively promoted our narratives in Portugal. And in the process, we have come up with pioneering academic publications that enhance and add another dimension to the study of Philippine history, both pre and colonial history, with the addition of the Portuguese perspective. And we are very proud of this. And I say this now and here because our partners in these projects are the Asian experts of the Centro de Humanidades or CHAM of the Universidade Nova de Lisboa. So Nova, in our books, you rock. As the Philippine ambassador to Portugal, it has been my mission to promote the linkages and narratives between the Philippines and Portugal from the historical, cultural, educational, economic, and political perspectives. This conference has definitely added the legal and judicial facet to those linkages and narratives. I wish the proponents of the project Erasmus Plus Capacity Building for Higher Education, CALESA, and all partner institutions present here today more power and success in all current and future endeavors towards achieving the goal of this project. Muito obrigada e bom dia.
Thank you, Madam Ambassador. We will now proceed with the first keynote speech of this morning's session. We are most delighted to welcome to the stage our keynote speaker, Honorable Alexander G. Gismundo, Chief Justice of the Supreme Court of the Philippines. Chief Justice Alexander G. Gismundo was appointed to the Supreme Court as Associate Justice on August 14, 2017, and later as the 27th Chief Justice of the Philippines on April 5, 2021. Prior to his appointment to the Supreme Court, he served as Associate Justice of the Sendigambayan, later becoming chairperson of its 7th Division. Chief Justice Gismundo obtained his law degree from the Ateneo de Manila University in 1984 and passed the bar in April 1985. He entered government service in August 1985 as trial attorney in the office of the Solicitor General. He was awarded as Most Outstanding Solicitor in 1998. Chief Justice Gismundo is a member of the Corps of Professors of the Philippine Judicial Academy and a professional lecturer in remedial law. He has taught various remedial law subjects at various schools and universities. Thank you.
Thank you for the kind words of introduction. Portuguese Constitutional Court Judge Jose João Abrantes, Philippine Ambassador to Portugal, Cecilia Ana Enferia, Philippine Associate Justice Mario Lopez, PhilJA Chancellor Rosemary Carandang, PhilJA Vice Chancellor Mariano del Castillo, Nova School of Law Vice Dean Professor Dr. Margarita Lima, Consul General Reginald Bernabe, delegates from the Nova School of Law, University of the Philippines, Ateneo de Manila University, San Agustin University, Ateneo de Zamboanga University, Universidad de Justo, University College, Dublin. Ladies and gentlemen, good morning. Today, the Philippine judiciary is at the crossroads of major shifts in legal paradigms and operational strategies, reflecting significant developments in both international law and information technologies. Reforms in legal processes have also been necessitated by a global health crisis, which threatened to put to a halt or at least suspend indefinitely court operations. But to understand this transformation, a quick look at the irrefutable and pervasive influence of Spanish colonial rule in the establishment of the legal system in the Philippines is unavoidable. While it was a Portuguese navigator who first charted our islands, it was Spain which laid claim to it. And while our islands were supposed to be situated within the demarcation line for Portugal under the Treaty of Tordesillas, the matter did not present itself as a pressing issue. And as documentary sources now enlighten, was resolved only 2 centuries later. But the Portuguese could have stumbled upon our islands and joined in the trade with our people even before Ferdinand Magellan arrived and laid the foundation of our Iberian connection. It is a fact that when Spanish colonizers first arrived in our archipelago, our forefathers had no written laws, but were governed mainly by rules based on customs, usages, and tradition that were transmitted from generation to generation. Spain established a more formal legal construct and more structured judicial system, which later evolved into present institutions, though some changes introduced by another foreign power, the United States of America. Thus, when the Philippines enacted its own penal code in 1930, which we refer now as Revised Penal Code, long after the Spaniards had ended their 333 years rule in the country, it took mainly from the old Spanish Código Penal of 1870. Even the Civil Code of the Philippines took its form mainly from the Spanish Código Civil. Indeed, so deeply rooted and far-reaching have been the Spanish influence in our legal system that up to this day, our jurisprudence still finds guidance and elucidation from commentaries of eminent Spanish scholars in their respective fields. But change is inevitable, and as people adhere to modern views and ideas, so laws must follow. Undeniably, the trend in criminal law reform has been towards liberalization and humanization, giving primary protection to the rights and freedoms of individuals as against immediately upholding the punitive and coercive powers of the state and reducing penalties and seeking alternatives to incarceration. But as I had emphasized before, reforms to our laws must necessarily conform to our values and aspirations as a people, and these are embodied in our own Constitution, which has provided the parameters within which we may develop and restructure our penal laws to achieve the objectives of criminal justice. Efforts to adopt modern views in our criminal laws are the domain of Congress, which has enacted, revised, and amended penal laws for the treatment of juvenile youth offenders, gender-based crimes, drug offenses, cybercrimes, and terrorism, to name a few. But to the Supreme Court, by constitutional fiat, belong the power to promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts. Almost 5 years ago, the Supreme Court issued Administrative Matter Number 02-2-18-SC, or the Rules on Juveniles in Conflict with Law, with the objective of ensuring that every child in conflict with the law is treated in a manner that recognizes and upholds human dignity and worth. This complements our Republic Act Number 2344, or the Juvenile and Welfare Act of 2006, which mandates the state to apply the principles of restorative justice in laws, policies, and programs applicable to children in conflict with the law. Only last year, the Supreme Court issued Administrative Matter number 21-06-08 SC, or the rules on the use of body-worn cameras in the execution of warrants, which utilizes technology, particularly body-worn cameras, in the protection of fundamental rights as mandated by our Constitution. These rules seek to complement specifically RA number 9165, or the Comprehensive Dangerous Acts of 2002, and serve as a check to the possible excessive use of force by law enforcement officers in the execution of warrants. On the same note, should a case be in the offing, it will not be long before the court issues similar guidelines on the use of drug sniffing dogs as a valid law enforcement measure to curb the rising cases of drug trafficking in the country. These guidelines would hopefully strike the balance between proactive law enforcement and the fundamental right to privacy of every citizen. The court has also made great strides in our goal of mainstreaming gender inclusivity and equality, not only in our institution, but through our decisions. In this regard, we have adopted the first ever organic guidelines on the use of gender-fair language and courtroom etiquette for the judiciary. As to terrorism, the Supreme Court recently convened an ad hoc committee for the formulation of the special rules of procedure in anti-terrorism cases, consisting of multiple sectors, with the object of coming up with guidelines to complement the recently upheld RA number 11479, or the Anti-Terrorism Act of 2020. The court has created other committees and technical working groups to review our rules and to formulate guidelines. No less important of which is the Committee on Data Privacy, Committee on Family Courts and Juvenile Concerns, technical working groups to review the writ of habeas data, to propose the writ of kalayaan, to review the writs of kalikasan and writ of continuing mandamus under the Judicial Committee on Sustainability and Environmental Concerns. As regards penalty, the Supreme Court issued AM number 20-0614 SC, approving the guidelines for the imposition of community service as an alternative penalty. This complements Republic Act 13362, or the Community Service Act, which authorizes the courts in its discretion to require community service in lieu of imprisonment for minor offenses in order to promote restorative justice and help jail decongestion. Significantly, in compliance with our treaty and convention commitments, the court in AM number 21-07-22 has set up a precedent by promulgating the rule on facilitated naturalization of refugees and stateless persons. This rule provides an expeditious procedure for the acquisition of Philippine citizenship by refugees and stateless persons recognized by the Philippine government. This rule, which is the first ever judiciary-led initiative of its kind in the global level, reaffirms the Philippines' long-standing humanitarian tradition of providing a haven to those displaced by war and armed conflicts and fearing persecution because of race, religion, and political ideology. When I assumed as Chief Justice in April 2021, it was a time of much uncertainty and anxiety as my country and the rest of the world were at the height of the COVID-19 pandemic. But we in the judiciary did not allow this invisible enemy to paralyze court operations and dampen our commitment to serve the public. We took advantage of the latest technology to continue the dispensation of justice, conducting remote court hearings and sessions via video conferencing. As to reforms on the judiciary as a whole, The Court and Bank just recently approved the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI. This institutional blueprint for judicial reforms is an amalgamation of ideas, aspirations, plans, and proposals for the pursuit of one overarching goal: the delivery of responsive and real-time justice. The SPJI is a plan powered by an innovation agenda to review and assess the organizational structure and operations of the various offices of the judiciary, and to develop and establish an information and communication technology infrastructure for the Philippine judiciary. It is a plan anchored on four guiding principles: timely and fair justice, transparent and accountable justice, equal and inclusive justice, and technologically adaptive management. These principles will propel us towards achieving three outcomes: efficiency, innovation, and access. Under the first outcome of efficiency, court systems, both adjudicative and administrative, shall be streamlined, and the performance of justices, judges, and court officials and personnel shall be effectively monitored and evaluated. Here, we'll undertake a judiciary-wide organizational review and restructuring. To drive performance excellence, we'll institutionalize a socialized health insurance system for officials and employees, and mandate subsidized annual physical and mental examinations for everyone. Mental health units will also be established in all court levels and in our administrative offices. Further, in recognition of the vital role of women in our court operations, we'll strengthen and multiply the child-minding centers throughout our courts. As we nurture the physical and mental well-being of our officials and employees, we will also step up our campaign to reinforce their ethical responsibility through the revision of the Code of Professional Responsibility and their campaign for ethical responsibility. Under the second outcome, innovation, we will shift and run all our adjudicative and administrative processes to digitalized platforms using the most appropriate and secure technologies, including artificial intelligence for legal research and court operations. Our trial courts will continue to transform as electronic courts using the much improved eCourt version 2. All of this and more will be part of the Judiciary Enterprise ICT Governance Framework, which will be accompanied by a 5-year ICT plan. As our courts relied on the use of technology in order to be able to continue with its work of dispensing justice during the height of the pandemic, we have decided, in line with our trust towards a technology-driven judiciary, to allow the conduct of all court proceedings through video conferencing even after the end of the global pandemic. As such, permanent guidelines institutionalizing the conduct of virtual hearings and electronic testimony are being drafted and will soon be promulgated. Early this year too, we conducted the first ever localized and digitized bar examinations. In line with our strategic plans towards running all of the judiciary's adjudicative and administrative systems digitally, the court has decided to pursue the conduct of all succeeding bar examinations in a digitized format. Third and final outcome is access. And under this, we will work towards bringing our services faster, closer, and more efficiently to the people. We will start with enhancing public access to information and legal services by strengthening our legal aid initiatives. We will spearhead a national summit on legal aid, which will showcase our two-pronged approach of revitalizing the Integrated Bars Legal Aid Program and reinforcing the Clinical Legal Education Program or CLEP under our revised Rule 138-A. Towards enhancing CLEP, a national summit on clinical legal education will also be held. PEB started reorienting legal education as early as 2019 when we promulgated AM number 19-03-24SC, otherwise known as the Revised Law Student Practice Rule. The institutionalization of CLEP was aimed at ensuring availability of legal services to marginalized sectors, especially in rural or remote settings. At the same time, student practitioners are exposed early to hands-on and experiential learning in an effort not only to develop their skills, but purposefully to stimulate and enhance their social consciousness. At the forefront of bringing justice closer to those who need it most will be our Electronic Justice on Wheels project. We will select the most congested courts and station our buses with judges at large on duty to extended periods until the case dockets are reduced to manageable levels. All this using the most advanced technology for case processing, video conferencing, notes transcription, legal research, and court-issued documents templating. For our Muslim brothers and sisters, we will also see to it that the foundations of the Sharia justice will be enhanced through an institutional review that will include the Sharia legal education system and rules of court. All this, the Supreme Court of the Philippines plans to implement within the next 5 years. We hope that as the years progress, we will see greater enthusiasm and support from all stakeholders. Let me close by thanking Erasmus Plus for this CALESA project and all participating schools, especially the Nova School of Law and the University of Malaga. Truly, may the sharing of knowledge rekindle our understanding and appreciation of a shared tradition between our countries. But more importantly, remind us all of, despite of our diversity, our oneness in our commitment for a just and humane society under the rule of law. Thank you very much.
Thank you, Chief Justice Gismondo. Today, we also have the honor to invite to the stage Honorable José João Abrantes, Justice Counselor of the Portuguese Constitutional Court, who will share with us his distinguished remarks on Chief Justice Gismondo's speech. Honorable José João Abrantes was elected in 2020 by the Portuguese Parliament as Councillor Judge of the Portuguese Constitutional Court. He is also a professor at the Nova School of Law and pro-rector of Nova University of Lisbon. Specialist in labor law, he is a member of several scientific associations and networks. In particular, he is the Portuguese national expert of the European Labour Law Network, which assists the Directorate General for Employment, Social Affairs and Equal Opportunities of the European Commission. For 7 years, he was the Vice President of Portuguese Association of Labour Law. He has many years of national and international experience as a specialist and consultant in the labor area, namely in matters of European and international law, having provided consultancy and technical assistance to ministries and other public institutions. He has more than 100 publications, especially in the labor area in Portugal and many other countries. Thank you.
Good morning. Dear Honorable Chief Justice of the Supreme Court of the Philippines, Alexander Gesmundo, dear Madam Philippines Ambassador to Portugal, dear Vice Dean of the Nova School of Law, my dear colleague and friend, Professor Margarida Lima Rego, dear ladies and gentlemen, dear colleagues, judges, and professors. It is a great pleasure and honor for me to be here with you all and to welcome you in this event. And I allow myself to be very brief. I was not supposed to speak so long, and I had nothing specially prepared for this occasion. And above all, after hearing the relevant communications by our three members of this table, Professor Margarida Lima Rego, Madam Ambassador of the Philippines to Portugal, and the Honorable Chief Justice, I allow myself to be still more briefly. But I want to tell you about my pleasure and honor, because this is really a very interesting project, the CALESA project, and I am since the beginning linked to this project, as we have talked yesterday in the Constitutional Court, and it was recalled by one of the professors here present, a colleague of Malaga. And this project is assembling several very prestigious universities from the Philippines, from Portugal, from Spain, and from Ireland. And so in an interdisciplinary perspective, and furthermore, in a global perspective from different countries and from different parts of the world. Yesterday, I have had already the opportunity to be with you, with a great part of you, the major part of you, in the Constitutional Court, and we have been exchanging our impressions about the experiences of the judiciary in the Philippines and also here in Portugal. And I have found really very interesting the different perspectives and the questions that were arisen during our talk, namely by the Chief Justice Alexander Gesmundo. It was really very interesting. We have been talking above all about the competencies and the attributions of the Constitutional Court. We have talking about the several modalities of unconstitutionality and the ways to control the constitutionality of the norms, the differences between concrete concrete control and abstract control, either preventive, either successive. And today, the presentation of the Chief Justice was really very clear about the evolution and the framework, not only the legislative, but also the judicial framework in the Philippines. And so I allow myself not to make a long comment, because it was really very, very broad and very complete, your presentation. As also the excellent presentations made by Madam Ambassador and by Professor Margarida Lima Rego. We have recalled already yesterday, and already today they were also here recalled, the long and ancient relations between our two countries, our three countries, the Philippines, Portugal, and Spain. Yesterday we have talked about Philip II of Spain, the first of Portugal, and also King of the Philippines, and all these long links that comes from the 16th century, from the beginning of the 16th century. Of course, I don't forget also Ireland, a very important country, and with excellent universities, and it's good that we are here all together. So it is my pleasure and my honor to be here since the beginning in this very interesting project. And I am in the Nova School of Law since the beginning, and above all, in the last years, we have remarked excellent improvements in our faculty due to the actual direction. We have here some members of this direction, Professor Margarida Lima Rego and Professor Francisco Pereira Coutinho. We have remarked very good, excellent improvements, namely in this field of the internationalization, in the international relations. And so I think we should all profit these possibilities of the Erasmus Plus, and particularly in this project, the CALESA project. It will be a pleasure to be part of it, but above all, for the Nova School of Law, and here I can also a little bit talk in this category with the permission naturally of my Vice Dean. It's very important, and I hope also that will be the feeling and also the experience of this fruitful cooperation for the other prestigious universities in this project. I have remarked that the Chief Justice, the Honorable Chief Justice, has talked about the pandemic and its impacts on public liberties. We have just talked yesterday about that, namely the case law of the Constitutional Court, the case law on mandatory quarantines, for example, in the framework of concrete control of the constitutionality, or on the provision by the law of the crime of disobedience for the violation or the non-respect of these mandatory quarantines. So the pandemic was global, so I think the problems and the solutions should also be global, and I think we have had the same problems either in Philippines, either in Portugal, in Spain, or in Ireland, all over the world. And so the exchange of the experiences for these difficult problems and the search of solutions, it's also very important in academic and universitary terms. So you are always welcome to Portugal, either here in the university, by my part also in the Constitutional Court. I hope we'll keep in touch, and thank you for this opportunity to address to you all. It was a pleasure and an honor. Thank you.
Thank you, Chief Justice Gismundo and Justice Abrantes. Closing the first session of the morning, we now invite you all for our coffee break, which will be served in the atrium outside this room. We kindly ask you to come back at 10:30 for the first panel session of the conference. We kindly ask the keynote speakers to please stay on the stage for the official photo. Thank you.